Welcome to Legal Aid of West Virginia's Family Law Information videos. This video will discuss the petition to allocate custody. This form is for individuals who need to ask a court to establish custody for decisions in parenting time that hasn't been decided in any other kind of case like a divorce or a guardianship or an adoption. This video only provides information. If you need specific advice about your case, you should try to contact an attorney or you can apply for assistance from Legal Aid of West Virginia. This form is available on the Supreme Court of Appeals website at www.courtswv.gov. You can also find more information about filing for custody on Legal Aid's website at www.lawv.net. This is the first page on the petition for custody. At the top, you'll fill in the county where you'll be filing your case. You'll leave blank the civil action number. That's a number that the circuit clerk will give you when you file your case. If you're the person filing, that you're the petitioner, so you would write your name here on the line where it says petitioner. And then you'll also need to provide your address and your phone number. The respondent is the person that you're filing the case against, so that's likely the other biological parent. So you'll provide their name, their address, and their phone number on these lines here. Moving down, on line A, you are the petitioner if you're the person filing the case, so you would print your name there. On B, you would put the county where you're currently residing in West Virginia. On line C, these are the instructions that you'll fill out on the second page, but you're supposed to get together the full names, dates of birth, and social security numbers for the children that you're asking the court to award custody for in this petition. If you have children with different parents and there aren't custody orders in those cases, then you'll need to file separate petitions for children that have different biological parents. At the top, you'll write the name, date of birth, and social security number for the children involved with this case. On line D, you would write what your relationship is to the children, whether you're the mother or the father. On line E, you would fill in what your relationship as the petitioner is to the respondent, something like ex-girlfriend, ex-boyfriend. If you were formerly married and then had children after that, you could write ex-spouse. If there was really no relationship other than to have children together, you could leave that blank. On line F, you would write what the children's relationship is to the respondent, so mother, father. On line G, you would put some information about what you know about where the respondent currently lives. If you don't know the address, you would mark that first line. On the second line, you would mark the county in West Virginia where they live, or if the person lives outside of West Virginia, you would put the last known address. H gives you the option if there's a second respondent or person involved to put information about where they live as well. If there's not a second respondent, just leave that information blank. On line I, if the parents last lived together somewhere, you would put that information, the county, the state, and the date where the last lived together. And if they didn't live together ever, or you're not sure, then you could just mark do not know. On line J, are the parents currently expecting another child together? If you don't know, mark that. If they are or aren't, then you would mark those boxes here. If it is yes, you're supposed to put in the due date for the child. On line K, it starts some information about where the children are currently residing. On the first part, you'll see the mother and the address for the mother. And then on the second part, it asks if it's the father, you would mark here and the address where the father lives. At the top of page 3, it gives you a little bit more space to fill out information about where the children are currently living. At the bottom of page 2, you could mark whether it was the mother or the father and provide their address. If the children are living with someone else other than a parent, then you would mark these lines here and fill in the information about where the kids are living, the name of the person, the relationship to the kids, and the address. On line 1 here, you'd fill in information about if the kids have lived somewhere else over the last 5 years other than the address that you've already provided. You'd need to list those addresses on these lines here. Question number 2 asks about custody cases that have potentially been filed in other states. So if you're the petitioner and the person filing and you've been involved in a custody case about these kids in another state, then you would mark yes here on this line. If you haven't, then you just mark no. On B, it asks whether the petitioner or the person filing knows of a case in the past or one that's currently filed in another state about these kids. If that is something that you're aware of, then you'd mark yes. If you're not aware, then you'd mark no. C, the last question on 2 asks whether the petitioner, the person filing, is aware of other parties that have had physical custody or claims of custody regarding these kids. So if someone has had a guardianship order or an adoption that potentially hasn't been finalized yet, that's been filed, then you would mark yes here. You're aware that there's somebody else that might have a claim regarding custody, or no, if that's not the case, then you would mark it here. Question 3 starts to get into questions about whether West Virginia is the right place or the state that has jurisdiction over the children and deciding custody for them. If the child's lived in West Virginia for the past 6 months, then West Virginia is typically determined as the home state. If that's the case, then you would mark A here, or B, ask questions about whether there's witnesses and information that would be most relevant to the case in West Virginia. So if that's the case, you would mark B here. Page 4 of the custody petition continues to ask some questions about whether West Virginia has jurisdiction over the kids and the law about that. Generally, if the children have resided in a state for 6 months before filing the case, and there's not a custody order in another state, then West Virginia is considered the home state for deciding custody. But if the kids haven't lived in West Virginia for the last 6 months, there can be some reasons that West Virginia might look at deciding custody. So C asks if the kids are now in West Virginia because they've been abandoned here. And that might be a reason the West Virginia court would look at exercising jurisdiction over a custody case. So you could mark that. Or D, it asks if the kids are here and there's a reason for West Virginia to assume jurisdiction because of an emergency like abuse or neglect. So you would mark D. E asks if there's no other state that has jurisdiction and the petitioner, the person filing, thinks West Virginia is the best place for the case to be heard. And then F is an option if another state has declined to hear custody because they felt like West Virginia was the place that was more appropriate to decide custody for these children. Question number 4 asks some questions about the county where you're filing the case. A asks if it's the county where the children are currently residing. If that's the case, mark that. B asks if the county where you're filing the case is where the respondent currently resides. If that's the case, you'd mark B. C asks if it's the county where the petitioner resides and the resident, and because the respondent is not a resident of West Virginia. So if that's the case, you would mark C. Question 5 asks some questions about the petitioner and the respondent. These are questions about whether or not the petitioner and the respondent are 18 or over. If they are not 18 or over, then a guardian ad litem would likely be appointed to represent their interests. On B, it asks some questions about the petitioner not being competent or the respondent not being legally competent. Again, if that's the case, then the court may appoint a guardian ad litem to represent their interests. And then C asks if the petitioner is incarcerated or the respondent's incarcerated. Again, that's for a potentially, if that's the case, a guardian ad litem might be appointed. Page 5 of the custody petition starts off with a question about child support, and if that's something the petitioner needs, then they should mark that top box there. Question 6 starts to ask a lot of questions about the parents and caretaking, how they made decisions, and the amount of time each parent spent caring for kids. So question A is a question that you should fill out if you're a parent of the children and you're filing this petition. And it basically says that both parents performed a reasonable share of making decisions for the kids and that should continue in a custody order. And it also says the petitioner believes that custody responsibility and time should be allocated based on the amount of time parents spent caretaking before the parties separated. Question B should only be filled out if the petitioner, the person filing, is not a parent of the children, and it basically says that the petitioner is asking that they be given all decision making and time for the child. Question C here is for parents, and this would be something you would want to look at carefully if you believe the other parent should have limited time or no time with the child. And some reasons the court might look at are in these boxes here, that if there's allegations of abuse and neglect against the children, sexual assault against the children, domestic violence. So you'll want to read carefully through those and mark the ones that are appropriate, and that you're asking that the other parent's time should be limited and that the other parent should not have the same decision-making rights as well. So you'll want to carefully read through those and mark those as appropriate. Question D and E are to be filled out if you're not a parent of the children and that you're filing this case. And those are questions about whether or not the mother or the father has engaged in abuse, neglect, or domestic violence such that the petitioner or the person filing thinks that the parents should have limited time or limited decision-making responsibility. Question number 7 on page 6 of the custody petition is basically where you're asking the court to do certain things in the case. So on line A, you're asking the court to order that the other side be required to pay child support. So you'd mark that and you'd fill in the name of the person you're asking to pay, the respondent. B is asking to prohibit the respondent from threatening, harassing, annoying the petitioner or the children in any way. And then line C is to order the respondent to maintain health insurance and help with healthcare expenses. So the next part is really the end, where you're signing and dating and then verifying the information that you've put in this petition. You should hold off on signing and dating here, and then even on the verification pages here at the bottom until you're in front of a notary public. You can usually find a notary public at the courthouse, in the circuit clerk's office, in libraries, in banks, but you'll also want to make sure you take ID and then sign these parts here and here in front of a notary public and then have it notarized before you file.